Walter Fox is my guest. He's certified as a specialist in criminal law by the Law Society of Upper Canada. Welcome to the program,
Welcome,
Walter.
Bob. How are you this morning?
Is this a new definition, this certification
Yeah,
thing?
it's about a year and a half old, and just like the doctors have specialists in various branches of medicine, we now have specialists in law, and I'm certified as a specialist in criminal law by the Law Society of Upper Canada. They're a stickler. I have to express it in those words exactly.
Now, you people in criminal law, does this Supreme Court decision that I mentioned affect you predominantly?
Oh, yeah, immediately, directly, and it affects the courts. It affects everybody who's involved in the criminal justice system, the police, the prosecutors, the judges, and including the people who may be victims of crime.
So how important a decision was it?
It's a Supreme Court of Canada decision. To me, it's one of those very dramatic turning point decisions by the Supreme Court of Canada that's going to take years to unravel the impact. It's going to take a long time for the ripple effect of this decision to make its way right through the criminal justice system.
Was it a surprise decision?
Well,
had you lawyers expected?
The issue had been bubbling around for a long time, and certainly had gone to the Ontario Court of Appeal on a number of occasions. Everybody was waiting for a Supreme Court of Canada decision on it, and it came, I believe, a week ago Friday in this case called Regina and Askoff.
Okay, now what we're going to do is we're going to go through Regina versus
Askoff, A-Z-K-O-F.
Askoff, and follow the case right through and then the ramifications. Let's start off from zero.
Okay. One of the bets that I think people miss in Canada is our criminal cases are as exciting and dramatic as anything that happens anywhere in the world. This case has all the elements. You start with 4 people in Toronto who are charged with the crime. One of them is an ex-boxer. I mean, that immediately gives you color and interest in the case.
Oh, high profile.
High profile. Now, this
and his name was?
According Eddie Mello.
Oh, yeah.
According to the reported decision, Mello and a friend of his, or a business associate of his, were in the business of supplying exotic dancers to taverns in southern Ontario. Along came a fellow from Montreal, from Quebec, named Belmont. And Belmont decided he was going to get into this business too. In fact, Belmont had been in the business a while earlier, had gone out of the business, and now was coming back, and he was going to provide exotic dancers, strippers for the various nightclubs in southern Ontario from Quebec.
Mello and his partner, did they have a virtual monopoly on the strippers?
It seems like that, because Mello, according to the case, Mello and his partners approached Belmont and they said, you can't function here in southern Ontario, this is our territory, and we're going to make sure you don't do that. This all happens, and this is an important date, in 1983, November of 1983. Mello and his friends make it very clear to Belmont he's not to operate in Ontario. Belmont then goes to the police, says, I've been threatened by these guys, can you protect me? And the police provide him with a chauffeur who is an undercover policeman.
Does he have what they call, quote, a body pack on him?
Well, he doesn't get to that point. It never quite gets to that.
Okay.
What happens is one evening after attending at a nightclub to encourage these people to order through Belmont, through him, Belmont leaves, gets in his car. Remember, it's being driven by a police officer who's undercover. And Mello and his friends, according to the decision, force this car off the road. The car gets pushed to the side of the road.
Hey,
Mello
this is
gets,
Miami Vice.
I'm telling you, it's as interesting as anything you're going to see anywhere on television or in the movies.
Boom, off the road, okay.
All right. Now,
Cop in the front seat,
right.
Montrealer in the back seat.
Mello and his friends come out, Askoff and whoever else, with a sawed-off shotgun and a knife. And they say to Belmont, now look, we told you. Well, before anything can happen, the area, of course, is on, and the vehicles are under police surveillance, and the police make the arrest. Pretty cut and dried situation, pretty
Mello and his partner get out of the car.
Right. Yeah,
do they threaten Belmont?
Yeah, with the sawed-off shotgun and the knife. Right, okay.
Boom, all hell breaks loose.
Right. Now the case comes to court. Well, 2 of the accused don't get out on bail. They do 6 months awaiting trial on bail. And it takes 10 months from the date of the arrest to have the case dealt with in the provincial judges' court. They then go to the high court.
What are they charged with?
They're charged with extortion, weapons charges, threatening with a weapon, assault with a weapon, dangerous driving, criminal negligence in the operation of a motor vehicle, a number of charges, all related to this incident at the scene. After 10 months, a preliminary hearing is held, and the matter proceeds then to the district court. And in the district court, which is the high court, it takes them 2 years to get to trial.
Why is that? Because of the backlog?
Because of the backlog in the court.
Are Mello and his partner still in jail?
No, Mello, I'm not sure it was Mello and his partner, but 2 of the 4 people who were arrested couldn't get out on bail for 6 months. But after 6 months, they're out. After 10 months, they have the preliminary hearing, and then 2 years later, they're on for trial in the district court in Peel. That's in Brampton. They come on for trial, and the Charter of Rights provides that everyone who's charged with an offense is entitled to a speedy trial. The trial judge says, and this is now 1985 or 86, he says, I've been sitting in this court since 1981. We have been backlogged by 2 and 3 years since 1981, and I'm going to throw this case out because of the delay.
Now, what are the Crown?
4 accused walk out of court completely acquitted.
Bam.
Bam.
Did he do this with any prompting from the defense lawyer?
Oh, yeah, there's a court application brought by the defense lawyer at the time. Now they get to the Court of Appeal. The Court of Appeal says, look, let's deal with the realities here. We know that accused people aren't in a hurry to get their case on for trial, and it looks to us, according to the Court of Appeal, that there was a scheme here afoot to lie in the bushes, to make the time go by before they got to trial, and then at the trial to say they've been denied their rights because of delay. And how have they been hurt? They haven't been prejudiced at all. We're not going to have any of this. And they send it back for a new trial. They say the trial judge was wrong, the delay doesn't apply, and we're back for a new trial. Well, the accused take it to the Supreme Court of Canada. And the Supreme Court of Canada says, look, we understand that the courts and the prosecutors may be interested in prosecuting everybody at all times, and the community has an interest. We like to see people who are charged with crimes, if we can, punished. But we also have an interest in seeing cases tried quickly. It is very demoralizing for a victim of a crime to see the person who's accused of that crime walking around for 2 or 3 years. And they did a comparison study in the court of all of the jurisdictions in North America. They said that the Peel region was the worst in North America. They said, in effect, very colorful language, was the worst jurisdiction for delay north of the Rio Grande. And they upheld and they established in law that, they upheld the trial judge and they established in law that a delay argument is a viable argument, and the accused doesn't have to prove he's been prejudiced. They said from the side of the accused person, for someone to carry a criminal charge around and know that they're charged and have to go to court some 2 or 3 years later is an intolerable burden as well. So they decided the community has an interest in speedy trials, the accused has an interest in speedy trials, and they've set down the rules, which seem to be 6 months to have your trial in the lower courts, and another 8 months beyond that if your case goes to the higher court.
All right, we just have a brief time left. Walter Fox, what are the ramifications of this Supreme Court decision?
Well, the ramifications are that cases will come to court much more quickly. There are also some very serious problems in how our courts deal with cases. For example, wherever children or women are victims of crime, the prosecutor has no discretion. Those cases have to go. Wherever there's an impaired driving charge, the prosecutor has no discretion. Those cases have to go. So 20 or 30% of the court time is already blocked out and allocated to a certain kind, because of these cases that have a high political priority.
Now these then, the only way they can get through the cases fast then is to reduce the charges.
Well, or to deal with them in a different way. But the prosecutors have no discretion. They must prosecute all impaired driving charges to the limit. They must prosecute all charges of domestic assault or sexual assault to the limit because of the political environment in which the courts function. My guess is something is going to happen to the prosecution and the approach to prosecution of those cases, and that may create some kind of political furor.
Right. Walter Fox is a criminal lawyer. Actually, he's a specialist in criminal law. by the Law Society of Upper Canada.